Hello everybody, I'm George from Ireland, carrying on with criminal law. So I was talking about actus reus yesterday, when crimes are caused and when there's a chain of causation. So when will the chain of causation be broken? When a crime leads to injury or even death. So it can be when there's a supervening act by a third party, i.e. not the defendant in the case and not the victim. But a third party comes along and does something else to the victim, either willfully or accidentally. It's either criminal or non-criminal, but does that break the chain of causation? So the act of the third party could aggravate the harm. So the third party could at the very least contribute to the harm, but that's seldom sufficient to break the chain of causation, especially the defendant's original act is still the substantial and operative cause of the injury. Smith 1959 was a case about this. Somebody was stabbed through the lung and then died. However, having been stabbed, was then the ambulance came along, the victim was dropped twice, and then was given artificial respiration, which was exactly the wrong thing to do to someone with a punctured lung. Nevertheless, Smith was found to be guilty of causing the death because he was the person who stabbed the victim originally. So the intervening acts were not enough to be the cause of death, not enough to exculpate Smith. Bear in mind what the autopsy report would have said about the death. Well, it was death by being stabbed in the lung. Might be other things, but that would be there at the top of the list. So this was the principle laid out in Smith. So listen to this. If at the time of the death the original wound is still an operating cause and a substantial cause, then death is a result of the wound, albeit that some other cause is also operating. Only if it can be said that the original wound is merely the setting which another cause operates, can it be said that death does not result from the wound. Putting it another way, only if the second cause is so overwhelming as to make the original wound merely part of the history, can it be said that the death does not flow from the wound. So now third parties can also react to the danger caused by the defendant's action. So somebody did something dangerous, others react, and that could cause injury. So it's unusual for these reactions to break the chain of causation. Look at Paget 1983. In this case, the police were seeking to arrest him. He had a gun. He had his pregnant girlfriend right in front of him. He was shooting at the officers over her shoulder. She's right in front of him, thinking the police will be chary about shooting back at him for fear of hitting her. She's innocent. Well, the police did return fire, and indeed it did hit that female and kill her. So Paget was charged with manslaughter, and he was found guilty. He appealed, said, but the police fired the fatal shots, I didn't. The Court of Appeal dismissed his appeal. They said, well, and this is the quotation, it is a reasonable act of self-defense against the act of the accused that caused the death of the third party. It does not relieve the accused from criminal responsibility for the death of the third party. Close quotation, as in his girlfriend was the third party. So if he hadn't opened fire, or indeed if he hadn't had her in front of him, then they would not have killed her. So he was held responsible for the death, even though he didn't fire the fatal shots. Okay, there are also medical interventions which can change the situation. Bad treatment can at least contribute to the death, as in Smith. Look at Cheshire 1991. The defendant shot somebody in the torso. The casualty was then taken to hospital. There was an operation performed. He had respiratory trouble. A tracheotomy was carried out. 6 weeks later, his wounds had almost recovered. His breathing was deteriorating and he died. The doctors didn't diagnose his problems and that the tracheotomy had been performed badly. The trial judge said that the medical mistreatment did not absolve the defendant, so the defendant was found guilty. Okay, and so there are also supervening acts of the victim. So the victim suffers whatever injury caused by the defendant, but the victim might do something to make the situation worse for himself. This is going to prejudice the chance of survival. But it almost never breaks the chain of causation if again, the defendant's action is still the substantial and operative cause. Holland 1841 is a case about this. So the victim suffered a major assault, hit with an iron bar. and then he was meant to have his finger amputated. He refused to do this. He was told he needed to do it to prevent tetanus. Anyway, so he died, but the defendant was still found guilty of the consequent death from tetanus. Blauer, 1975. This is a case where the defendant stabbed the victim. The victim suffered exsanguination. The doctors informed the victim that she needed a blood transfusion, otherwise she would expire. Now, on religious grounds, she refused, and indeed she perished. So the defendant claimed that he was not the one who occasioned the woman's demise. It was her own stupid fault for refusing a blood transfusion. But anyway, remember the old principle, you take the victim as you find him. Nevertheless, that the defendant was found guilty. What would the autopsy say? Well, blah, 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 this injury, and okay, she didn't accept the blood transfusion, but she wouldn't have needed a blood transfusion had it not been for the crime he'd committed against her. Now, there are also escape attempts, which can lead to injury. So if the victim suffers some wound while trying to get away from a defendant committing a crime, then the defendant is still criminally liable, so long as the evasive action is consequent upon the defendant's offence. Roberts, 1972, is a case about this. The victim jumped out of a moving car in reaction to a sexual assault. The Court of Appeal said that the defendant was guilty because the victim's injuries were resultant from what D had done, the defendant had done. So there's a causal chain created, and it was a foreseeable reaction. It was a reasonable reaction to jump out of the moving car. Okay, so it was only if the victim does something really crazy that the chain of causation will be broken. Williams and Davis, 1992, is a similar case, and the court said, well, would a reasonable person have done what the victim did if placed in that situation? And so that's a test. So think about suicide. Anyways, it's hard to say if this is seen as a reasonable or foreseeable reaction. Dhaliwal, 2006, there was a long period of domestic abuse between a husband and wife, which led to suicide. So the court had to consider, is the defendant guilty of causing the suicide? And this is what the Court of Appeal ruled. Where a decision to commit suicide has been triggered by a physical assault, which represents the culmination of a course of abusive conduct, it would be possible to argue that the final assault played a significant part in causing the victim's death. Close quotation. The key word there was possible. In other words, if the suicide was a reaction to the abuse, then the defendant is not liable. But if it's a particular wrongful action that leads to the suicide, then the jury might, I repeat, might find the person guilty. 2007, there was R against Wallace, and the suicide had resulted here. The defendant had committed a crime. So the defendant had thrown sulfuric acid over his ex-boyfriend. Is a man who got injured. The woman threw it over him whilst he was a kip. The man was blind, he was paralysed, and blah, blah, blah. So he went to a euthanasia clinic in Belgium, and he had himself killed. He couldn't carry on living like that. His life was unsupportable, so he thought. So the defendant was charged with murder, and the judge said, well, we can't look at the chain of causation here, because the period between the crime and the death is too long. So throwing corrosive fluid on somebody is a crime under Section 29 of the Offences Against the Person Act. The Court of Appeal said that the trial judge had made a mistake. He'd erred in law in taking the question of causation away from the jury. And the jury has to be able to decide if what the victim did was really directly because of what the defendant had done. Anyway, so there was a trial, and the defendant was found not guilty of murder. So how could the chain of causation be broken? Well, it can be, but it's hard to see. If it's Novus, actus, interveniens, a new act intervenes. Jordan, 1956, is a case about that. So if it's something very powerful and independent of the original crime, then it breaks the chain of causation. So the Novus actus interveniens has got to be voluntary, has got to be separate from the initial crime, and has got to be enough in itself to cause the harm sustained by the victim. And we could look at a case in the United States, People Against Elder, 1894. The defendant hit the victim fell down, and then another person, a bystander, gave the victim a good kicking, which resulted in the defendant dying, so the victim dying. The defendant was found not guilty of murder because although the defendant had contributed to punch the person to the floor initially, and then this other person who wasn't part of the plot, this bystander, had come along and administered several kicks. Or there's also Rafferty, 2007, another case where there was Novus actus interveniens, and that was held to break the chain of causation. Okay, so anything else I could point out about these things? The chain of causation is broken if we know that there's a separate and voluntary act, and that would be enough to cause the injury that was suffered. If the victim's death happened because the victim was already in a debilitated state, consequent upon the initial crime committed by the defendant, the chain of causation is not broken. So it's difficult to guess how the victim is going to react. And there are many cases, Holland, Roberts, and Blau about this. So then supplying drugs is a key case. There lots have been drug cases. The supplier of drugs has been charged with manslaughter after the person who took the drugs died. So is selling or giving away drugs for free, is that what causes the death? So we ask about foreseeability. But some people say, well, giving someone drugs doesn't make them take the drugs. They could not take them. They could give them away to somebody else. It's actually swallowing it, injecting it, whatever. That's what causes the death. Seems crazy to me. I think clearly the drug dealer is responsible. But anyway. So Finley 2003 was a case about this. So the Court of Appeal said that the supplier of the drugs was responsible for the death, since he knew the person who received the drugs was going to inject himself. Kennedy 2007, number 2, there's another case, and it's the test here is not whether it was foreseeable, but whether it was voluntary. Did the person who died of the drug overdose do so, take the drugs of his own free will, and did he do so with sufficient knowledge? So if it's a free and informed choice, then that breaks the chain of causation. If it's not free, or if it's not informed, then the victim lacks mental capacity, for example, is under 18, or they think they're getting cocaine, actually they're getting heroin, something like that, then that would break the chain of causation. If the person who supplies the drugs sees that the victim is going very badly, has lost consciousness, or is approaching death, and doesn't call for help, then that's different. Then they can be convicted. There's a breach of duty to save them if you can, because you caused the harm. All right, that's as in Evans. So, Novus actus interveniens, these acts are unusual. They have to be separate from the original act by the defendant, and they have to be enough in themselves to result in death or the injury that was sustained in the end. So they could be because you go to hospital for your injury and then a fire breaks out in the hospital and kills you, something like that. Or you're being taken to hospital in an ambulance, a big truck comes along and kills you. Or Bush against Commonwealth, 1880. Here the victim died of scarlet fever when in hospital, and he was in hospital because he had to be treated for the injuries that the defendant had caused to him. Therefore, the defendant was not held to be liable. No, but if the defendant does something which has increased the chance of injury, then that's different. If the defendant leaves a victim unconscious beside the side of the road, and the victim gets up and in his hazy state wanders across the road and gets knocked down by a car, the defendant's still liable. Corbett, 1996, was a case about that. If the defendant causes the victim to become unconscious, leaves the victim on the beach as the tide is coming in, the tide comes in and drowns the person, then they're still guilty. Or leaves the person unconscious in a cemetery before ravening beasts come and kill him. That was the Harless case, 1560. The defendant is still liable for the death. Okay, so that's just a little bit about Novus actus interveniens. Toodaloo.